I'm extremely happy today. I have a feeling of coming back to my tribe. Sandeep, can you hear me properly? If my appearance on screen is correct and if you are in a position to hear me properly, please put a thumb on the WhatsApp. I will accordingly proceed ahead. All right, thank you very much. I begin. I, at the outset, desire to express my sincere gratitude to our dear friend Sandeep Dongre, who has taken endless efforts to educate me as regards how to speak online and the other nitty-gritties of this technology. Let me confess, I'm a novice in this field. Virtually about 2 hours were spent by Sandeep to educate me. Thank you very much, Sandeep. Well, our legal profession is very peculiar. If you compare our profession with the rest of the professions, you will find that peculiarity. See, if you take a case of a medical profession, you'll find that when a person becomes a doctor, he opens up his clinic or hospital and starts his medical profession, of course, with the help of its subordinates. Take the case of the chartered accountants, take the case of architects, you'll find that they all work from their office. Maybe ours is the only profession which virtually brings us together every day. We come together, we chat, we carol, and then we have a cup of tea. This peculiarity, in my opinion, brings about a feeling of togetherness. The bond, according to me, is greater in our community. Well, this COVID-19 pandemic had disconnected us for last about 2 months. I must express my sincere gratitude to our dear President Prashant Kadam, Secretary Sanjay Mhatre, and all other office bearers for having provided this platform to come together and discuss on the subjects of our liking. Well, the topic for our discussion today is the overview of the specific Relief Act 1963 and in particular the recent amendment introduced in this act in the year 2018. I feel every act has its own time. Well, when I joined the practice, I remember that the courts were virtually flooded with the Bombay Rent Act cases. The words landlord, tenant, standard rent were very, very familiar in the courts. I have heard luminaries of our bar arguing out on the subtle distinction of section 12.3a and 12.3b of the Bombay Rent Act. That distinction is so minute, so microscopic, that I used to have scared that I'll never understand all this. Later on, lot of developments occurred. You are aware that the metropolis like things, say Mira Bhayandar or the New Bombay, were villages at that point of time. Later on, tremendous developments, infrastructural developments began, and today we see that Mira Bhayandar and New Bombay are the metropolis cities like. So this all eventually replaced the Bombay Rent Act litigations by the litigations arising out of the contracts. The litigations under the Contract Act, and hence of course the litigations under the Specific Relief Act are thus on the rise. You will find that today about 60 to 70% of the matters that we handle, they revolve around the Specific Relief Act and the Indian Contract Act of 1872. The study of the Specific Relief Act is therefore imperative. Well, what is Specific Relief Act? If you compare the name of this act with the names of other statutory provisions, you will find that this does not by itself indicate anything. Take the case of a Contract Act. We get to learn that this act deals with the contracts and the contractual relations and obligations. Take the case of a Transfer of Property Act, take the case of Succession Act, Ownership Flats Act. Almost all these acts, they tell us as to what this act is about. The Specific Relief Act by itself, however, does not indicate anything as to what is this act in regard to. See, there is a maxim, ubi just ibi remedium, a Latin maxim it is, the meaning of which is, where there is a right, there is a remedy. The Specific Relief Act does not per se, that is by itself, create a right, it provides a specific remedy. For example, if there is a contract or an agreement between two parties and one party commits a breach of the contract, the party which has suffered the breach shall have various remedies, various reliefs available. That party can sue for damages. The party can sue for cancellation of agreement. The party can also sue for the specific performance. So the specific performance is a specific relief. Even under the general law, you will find that if a person has certain rights in respect of some property or something, and that right is infringed or is likely to be infringed, the aggrieved party can bring an injunction suit, that is a specific relief again. So therefore, these reliefs which are considered in the Specific Relief Act are the reliefs in species. The Specific Relief Act aims at the exact fulfillment of the obligations of the parties. Well, you must be aware that the laws can be broadly divided as the substantive laws or the procedural laws. The substantive laws is a set of laws which lays down a mandate as to how the members of the society should behave. The substantive laws lay down the rights and obligations of the parties. The procedural law lays down the ways and means. The procedural law tells the method as to how would the substantive laws be enforced. Now consider, it is a Specific Relief Act. In which category would you all put the Specific Relief Act in? Is it a substantive law? No, it does not. Because it by itself does not create any right. It merely tells you as to what is going to be the specific relief that you can ask for. So it is certainly not a substantive law. Is it a procedural law? No. In the strict sense of the term, it cannot be called as a procedural law. It can well be called as a remedial law, which is closer to the procedural law. When a person is aggrieved on account of breach of the rights available to him under some provisions of law, he can take shelter of the Specific Relief Act. If it is a matter of contract, well, he can file a suit for specific performance. If it is a matter of infringement or likely infringement of some of his rights under some laws, he can bring a suit for injunction. The Specific Relief Act, as I said, therefore, aims at the exact fulfillment of the obligations. It is a relief in species. Well, the Specific Relief Act is not new in the law books. This act was formulated firstly as far back as in the year 1877. This act remained in the law books for about 85 long years. After independence, and on account of several changes, the need was felt, and therefore the Specific Relief Act of 1877 came to be repealed, and the Specific Relief Act which is in vogue today, that is the Specific Relief Act 1963, came into force. Lot of changes have really occurred even after 1963. I remember, actually, our generation is a witness to several developments all these years. I remember in 1971, when the Indian cricket team had gone to West Indies for a cricket series, Sunil Gavaskar, a famous cricketer, had made about 5 centuries. I distinctly remember that to hear the commentary, we all friends used to gather in an open space, one having a transistor, rest just listening to it, the wobbling voice. And then we used to say whether it was a 4 or whether it was a 6. What I'm trying to point out is that later on, the transistors were replaced by the black and white televisions, then colored televisions, the computer was introduced, several economic developments occurred all over the globe, as also in India, because of the tremendous economic developments. The trade and commerce internationally increased. Now, because of this tremendous economic development, as I said, naturally, several commercial activities were also started in India. The new concepts were introduced. The foreign direct investment started coming in. The public-private partnerships were introduced. I believe you all understand what are public-private partnerships. Public-private partnerships are the kind of partnerships wherein the infrastructure which is available for the public at large is built by the government at the price and cost of a private organization. In return of that private organization spending money and incurring cost for the infrastructure, the government in turn permits such an agency to maybe collect the tolls or to recover the cost incurred by it by awarding certain privileges for a couple of years. The road development. We know that the roads are developed today. We see a tremendous road infrastructure having already been built and also being built upon. Now, this all expense is incurred by the companies like IRB and many others. In the return of such companies having incurred the cost for construction and maintenance, the contract is awarded to such companies to collect the toll for a couple of years. This is what is a public-private partnership, PPP. So because of these infrastructural developments, the public-private partnerships were introduced. The international traders were also attracted. There started global contracts, global agreements. These international traders who were interested in pouring in their money and maybe also to make contracts or agreements with the Indian government or Indian companies, they were wary, they were cautious. They were cautious because the laws then prevalent in India were not quite suitable to them. They were not sure of the manner in which there would occur a performance of the contract. They were also not sure, they were pretty wary as to the time that would be required for the disposal of cases. Now, this all needed a change in law. The government of India also took up an initiative to make sure of ease to do businesses. So the initiative of the government of India in respect of ease to do business, the tremendous infrastructural projects which started, the introduction of new terminologies like the public-private partnerships or the foreign direct investments required the change in law. The World Bank makes a rating of various countries to find out the situation prevalent into the respective countries, and to see as to how compatible are the laws of that country in the matter of ease to do business and the specific performances. See, the traders who pour in huge amount of money, maybe from outside, they would always be interested in making sure that the contract is performed. So this all, as I said, the World Bank makes a rating. At the relevant time, the India ranked at serial number 164 as far as the specific performances were concerned, and at number 100 as regards the ease to do business. A decision, see, at the relevant time, as I said, the Specific Relief Act 1963 was in force. It is still in force, of course, with amendment. But the peculiarity of that act of 1963 is the discretionary powers were given to the courts to decide the matter. So, well, if one filed a suit for specific performance of a contract, there were several impediments in the matter of grant of specific performance. On the contrary, the text of the original Specific Relief Act 1963, if we go through, you will find that wide discretionary powers were given to the courts of law. Now, this discretion naturally used to tilt the court decisions in granting the damages more than granting the specific performances. Now, this situation needed to be changed, and therefore the government decided to drastically amend the substratum of the Specific Relief Act 1963. The discretionary powers which were available to the courts were thought of, kind of done away with. It was also thought that the infrastructural projects which are in public interest, finally, they are not impeded, they are not obstructed by any orders of injunction or any discretionary powers of the courts, and therefore the lawmakers thought it appropriate to incorporate an amendment in the Specific Relief Act which would take away the discretion of the courts and make really the grant of specific performance a rule and refusal an exception. To overcome the difficulties faced in the execution and performance of the development projects, to change the substratum and make the grant of specific performance a rule, the introduction of the terminologies like public-private partnerships, it was eventually decided to change and alter the Specific Relief Act 1963. The bill was accordingly presented. The Parliament passed the bill on 15th March 2018. The Honorable President of India gave its assent on 1st August 2018. The Specific Relief Act, Section 1, Subsection 2, that is the Amendment Act, lays down that this act would come into force on promulgation of a notification by the government in that regard. The government accordingly promulgated a notification on 19th September 2018, and the amendment was introduced and brought into force in the Specific Relief Act with effect from 1st of October 2018. So we are with the Specific Relief Act today, which is basically of 1963, but it is with amendments of the year 2018. If you just recapitulate the scheme of the Specific Relief Act 1963, you will find it's a very small act, that sections 5 to 8, they deal with the recovery of possession. Sections 9 to 25 deal with the specific performance, the defenses available, the personal bars to the grant of specific performance, the matters which are in which the specific performance is not capable of being granted. So the second part, the first part, see, the Specific Relief Act of 1963 can be categorized into 6 parts. Part 1, between sections 5 to 8, recovery of possession of immovable and movable properties. Sections 9 to 25, which deal with the specific performance, primarily grant and refusal, etc. Then section 26 deals with the rectification of contracts. Section 27 to 33, they deal with the cancellation, rescission of the contracts and instruments. Sections, then the fifth one will be the declaratory decrees covered under section 34 and 35, and the last part is covered in sections 36 to 42, namely the preventive reliefs. So these are broadly the 6 categories by which, under which rather, the specific reliefs are granted to a person. Now we have to concentrate on the amendment, but in order to understand as to what is the amendment introduced and in what way has the amendment changed the basic ethos and substratum of the Specific Relief Act 1963, it is necessary to just have a quick glance on these provisions. Now, sections 5 and 6 of the Specific Relief Act are basically the sections which we often use. See, if a suit for possession is required to be filed, a shelter can be taken maybe of section 5 or section 6 of the Specific Relief Act. Section 6 provides a speedier remedy. That speedier remedy is, see, if the suit is to be filed under section 6, all that the plaintiff is required to plead and prove is, number one, that he was in possession of the immovable property, regardless of what is the title. All that he needs to prove is that he was in possession. Then next is that he was dispossessed. So he must prove firstly that he was in possession. Then he must prove that he was dispossessed. And thirdly, he needs to prove that he was dispossessed without his consent. If a suit is brought under section 6, it must be brought within 6 months from the date of disposition. Section 6 is a quicker remedy. Such suit cannot be filed against the government, and no appeal lies from the decree passed in a suit under section 6 of the Specific Relief Act. Now, section 5 of the Specific Relief Act is again a suit for recovery of possession. But there, a person who files a suit is required to prove his title qua the property. Means he is required to show that he is either the owner or the lessee or the mortgagee, or he has some right to remain in possession in respect of a property. The suit under section 5 can succeed only if a person proves his title over the property. For the success of suit under section 6, a person is not required to prove his title. All that he is required to show that I am in possession, I was in possession, I am dispossessed, and my dispossession is without my consent. That's it. Now, an amendment which is, well, not very significant, I would put it, is introduced in section 6 by way of an amendment of 2018. Now, previously, the suit under section 6 was capable of being filed only by a person who was actually dispossessed or by a person claiming through or under him. Now, by an amendment, the words were added that also by any person under whom the person who was dispossessed claimed his possession. So consider that if a tenant was dispossessed by a miscreant, by a wrongdoer, the tenant could of course bring a suit under section 6 if it is within 6 months. But prior to amendment, the landlord through whom the tenant claims to be in possession was not competent to file a suit. Under section 6 I am talking about. Now, after an amendment, the words "a person through whom a dispossessed person claimed possession" is also included, and therefore an additional weapon is given in the hands of the owner to sue under section 6. This amendment is comparatively, I would call as not very significant. The basic amendments which are introduced by the Amendment Act of 2018 are in sections 10 to section 25 of the Specific Relief Act. Now, if you recapitulate the caption of section 10 prior to its amendment, you will find that the caption was the cases in which, caption means the shirsha, the heading, the cases in which the contracts can be specifically performed. Now, the original section 10 said that the specific performance can be granted only if there existed no standard to ascertain the damages caused by the breach. The second parameter to succeed to get a specific performance under the old act was that the plaintiff was also required to prove that a compensation in monetary terms would not afford an adequate relief. So unless these parameters were satisfied, the specific performance was not to be granted. It was a discretion. Even the heading of section 10, as I said, which said that the cases in which the specific performance can be granted, indicate that it was a matter of discretion for the courts, and the tilting of the court was in fact in granting damages and not the specific performances. This was original section 10. Now we can read section 10 juxtaposition, that is conjointly with section 20, which again conferred a discretion upon the courts. Section 20 of the Specific Relief Act very clearly said that the specific performance shall not be granted only because it is lawful to do, but it can be granted and the court shall exercise the discretion only on the sound and reasonable judicial principles capable of being corrected by a court of appeal. So therefore, a conjoint reading of section 10 and 20 of the Specific Relief Act as it existed prior to amendment would show that the courts had wide discretionary powers. As I said, it was one of the prime objects of the lawmakers to change this substratum or the basis and make the grant of specific performance a rule and refusal an exception. The old section 10 was therefore totally abrogated. That was removed from the law books and a new section 10 was introduced. The new section 10 is very short. It simply says that the specific performance shall. Instead of may, the word shall was used, meaning that it shall be granted means the mandate. It was made mandatory to grant the specific performance. It was kind of made a rule to grant a specific performance. The only exceptions were as spelled out in section 9 and section 10 itself. Section 10 reads that the specific performance shall be granted except in cases falling under section 11 subsection 2, section 14 and section 16 of the Specific Relief Act. So naturally, by a plain reading, of section 10, one can understand, as amended, one can understand that the discretion of the courts in granting the specific performance is virtually taken away. Now it is made mandatory to grant the specific performance. Now the grant of specific performance is a rule and refusal is an exception. Now I remember one old authority of the Honorable Supreme Court, which was of 1979. In that authority, the Honorable Supreme Court had laid down the principle that the grant of specific performance is a rule and the refusal is an exception. This was, of course, an obiter dictum, means a passing reference, and therefore it was never considered to be having what is called as the binding effect on the courts. Therefore, possibly the suits previously used for specific performance used to be considered on the basis of discretion. That discretion was totally done away with. Now, the very section, it has of course limited exceptions. It doesn't mean that if you file a suit for specific performance, it will be granted as a matter of course. If that was the idea, then one would not be required even to issue summons to the defendant. That's not it. The rule it is, but exceptions are also, though limited, they are spelled out in section 11(2) subsection 2, section 14 and section 16, and obviously under section 9. Section 9 of the Specific Relief Act states that the defenses available in a suit for specific performance shall be all the defenses which are available under a contract. Now, when you file a suit for specific performance, obviously you file a suit on the basis of a contract. Now, if it is on the basis of a contract or an agreement, naturally all the defenses available under the Contract Act should remain available. For example, voidability of contract, breach of contract, the coercion, fraud, misrepresentation, mistake, make the contracts void, the purpose or the object of a contract if unlawful, that would make the specific performance impossible. But these are the limited grounds. Then section 11(2), which simply says, 11(2), when I say, I mean that section 11 subsection 2. There is a minor amendment introduced in section 11, and that amendment is the word may, because previous to the amendment it was stated that the specific performance may be granted. Now that is changed and it is the word may is replaced by the word shall, again to indicate that discretion is taken away. Now section 11 subsection 2 states that if a trustee, if the contract is made by a trust, and if the trustee has acted in excess of the powers vested in him, the contract shall be not capable of being specifically performed. So the defense available under section 11 subsection 2 is only in case where a party against whom the suit is filed is a trust, not otherwise. Then comes section 14 of the Specific Relief Act, which also lays down the defense kind of, because section 10 says that the specific performance shall be granted unless it is affected by these sections. So section 14, the caption of section 14 of the Specific Relief Act is the cases in which the specific performance cannot be granted. Now, about 3 of the previous defenses available in a suit for specific performance are retained. Which are they? The contracts which involved a continuous duty which the court was not capable of supervising, were not specifically performable. Then the contracts which were determinable in its nature, like the contract between the owner and a contractor just to build a building, not a developer, is determinable in its nature and therefore not specifically performable. One other aspect which was also found in the old section 14 was that the contract which is dependent upon a personal qualification is not capable of being specifically enforced. Take a case, suppose if there is a singer and he has contracted to perform the concerts into a music hall on the given dates in a month. Now, if he is not able to do it for any reasons, he falls sick or whatever, can the owner of the music hall sue the singer to sing a song? No, obviously, because the singing is a personal qualification, and therefore such contracts can also not be specifically performed. So these are all the differences which are even otherwise available under the old act. They are retained. One very interesting new concept about which I shall make a reference a little later was introduced in section 14, which is kind of a defense, is that if a party takes up a substituted or obtains a substituted performance, the specific performance suit cannot succeed. So this is one defense. I'll make a detailed discussion about the substituted performance a little later. Then section 16. Section 16 again, which forms the defenses in the suit even after the amendment in a suit for specific performance, are the personal bars to the reliefs. The same caption is retained. What is added up is, see, in old section 16, there were two requirements for a person to succeed in a suit for specific performance. Requirement number one was that he must plead. That means he must mention in the plaint his readiness and willingness to perform his part of the contract. And not only that he must plead, but he must also prove the readiness and willingness. Now, by an amendment, because this is a hyper-technicality, to plead and then to prove, by an amendment of 2018, this hyper-technicality is removed. Now it is no more necessary for you to plead that you were ready and willing to perform your part of the contract. You must have, of course, prove that you were and are ready and willing to perform your contract. But the requirement of pleading is taken away, which was a hyper-technicality. The reason is that now the grant is kind of made a rule. The grant of specific performance is kind of made a rule. So these are the defenses, the only defenses which are now available to a person if he brings a suit for specific performance. If the other party, brings a suit for specific performance. What I want to emphasize is that the basic objective of the lawmakers while making an amendment was to take away the discretion of the courts in granting suits for specific performance and make it as an exception. The refusal as an exception. What I'm trying to tell you is that this was introduced in order to inspire confidence in the minds of the global parties who were interested in pouring money in Indian economy and whatever. So this gave a confidence. The purpose was accomplished by this amendment, by making the people know that now if you come to India and make the contracts, remain assured that the chances of the specific performance being granted are pretty very high, and it is no more a matter of discretion to the courts of law. Now there is one amendment introduced even in section 21, very interesting. As I said, the basic objective in making amendment was to remove the discretionary powers and make it as a mandate. Previously, if you remember, prior to amendment, we used to file suits for specific performance and in the alternative for damages, because we were not pretty sure that the specific performance will be granted. So why let us err on a safer side? The suit for specific performance primarily, and in the alternative suit for damages. If in substitution, means we used to pray that if the court is not inclined to grant what is called as a specific performance, then grant us the damages in the alternative. Now there was an amendment introduced in section 21 which had previously permitted even filing a suit for damages in substitution, means specific performance or damages in lieu of specific performance. That was taken away. So today if you file a suit under the new act, the amended act, you need not, or rather you cannot file a suit for specific performance in the alternative for damages. Now you will have to choose. You cannot, now file a composite suit. You will have to choose whether you want to file a suit for specific performance or maybe for damages. You can of course file a suit for damages under section 73 of the Contract Act. But if you file a suit for damages, then specific performance cannot be had. If you file a suit for specific performance, remain assured that you are going to succeed. The rule is that. So unless there are some exceptions, exceptional circumstances, you can always succeed. So why worry? Why are you skeptical as to whether specific performance will or will not be granted? So to make sure that to reinforce rather the idea in the mind of people that now you need not worry, your suit for specific performance is most likely to be granted, the words in section 21 which mentioned that it can be filed in substitution also were removed. Now section 21 says that you can file a suit for specific performance, and in addition to that you can claim damages. So an additional protection is afforded. Now after amendment you will see the law is more in favor of granting performances rather than refusing performances and maybe granting damages. So what I'm trying to imbibe in your mind is that this discretion is taken away is pretty much clear when we run through sections, the amendments introduced in sections 10 to 25. There is one small amendment introduced in section 25, but that is really not significant. The section 25 previously said Arbitration Act of 1940. Now we know that this act is long replaced by the new Arbitration Act of 1996. So only that amendment was done, nothing more. So that amendment is also not very significant. Some more ideas the lawmakers had in suggesting this amendment. Now we are aware that due to the advent of time, the globalization, the nitty-gritties into the contract the agreements have increased. Lot of technicalities are involved in the contracts. Now, sometimes it becomes difficult for the courts of law. It is possible that it may become difficult for the courts of law to understand the subject in its proper perspective. Considering that several technicalities, say engineering technicalities, considering all that, considering or anticipating that some experts' help will be required, Section 14 was, one more section was added as Section 14A, Section 14A in the law books, giving a power to the courts to suo motu appoint experts. If the court feels that this contract is very technical and maybe that the proper understanding of the terms of the contract is not possible unless the technical help is obtained, say of the architect or of some engineers, whatever, the courts are given a specific liberty, a power under new Section 14A to appoint the experts. Now the report, of course, these experts can be appointed by the court either suo motu, that is by itself, or at the instance of some party. The report which the expert would submit shall become a part of the court record. Mind you well, that is what is Section 14A, subsection 3. So the expert assistance will be available to the courts to more effectively decide the contracts, is all what is clarified in Section 14A, and this is one other part that was sought to be newly introduced in the law books by way of an amendment. Some time back I have stated that there have been several infrastructural projects undertaken. Now, these infrastructural projects are obviously in public interest, say the construction of roads, the construction of metros, and whatnot. These are all eventually for the benefit of the public at large, and in order to protect the public interests, the discretionary powers of the court to grant an injunction in the matter of infrastructural projects is also taken away. The power of courts now, there is Section 20A, B and C added up. These newly added sections 20A, 20B and 20C clearly lay down that if the contract is in respect of an infrastructural project, the court shall have no power to grant an injunction. No injunction shall be granted. So consider a case of construction of a road. The government has awarded a contract to, say, company X, and there arises a dispute. The government terminates the contract. The company X files a suit, seeks an injunction. Now, injunction will eventually have an adverse effect on the public at large. That should not be impeded, is the contemplation. And therefore, after amendment, the mandate is laid down in the law book that the courts shall not have a discretion to grant injunction in the respect of infrastructural projects. Now, which are the infrastructural projects for which the injunction cannot be granted by the courts in any circumstances? There is a schedule to the Specific Relief Act after amendment added up, and in that schedule several projects are enumerated which are said to be the infrastructural projects in which the injunction cannot be granted. So the public interest is taken care of while making this amendment. Now, we have seen that the objective of the lawmakers in making an amendment was fourfold. One was to take away the discretion. I have already discussed with you that in sections 10 to 25, this discretion is taken away, is very clear, obvious. The other objective was to introduce the concept of expert assistance, which we have discussed. The third one is the protection to the infrastructural projects, that also we discussed. Now, like what sections 20A, 20B and 20C are added up, there is also an amendment in section 41 HA. By that section 41 HA, it is reiterated that the injunction shall not be granted, shall be refused, mandate, in case of infrastructural projects. So it is no more possible for any individual, any organization, any contractor to create any obstructions in the infrastructural projects by bringing a suit for injunction. Remain assured that the courts will have no discretion, and as per the mandatory law, the injunction shall be refused. That is what is the third angle. Now that all brings me to the last angle, which is altogether a new concept. There is going to be a lot of debate, I am confident, about this concept, which is introduced by new section 20. See, new section 20 is altogether on a different facet. This introduces, section 20 newly introduces a new concept of substituted performance. What is a substituted performance? It was never previously in the law books. Mind you well, substituted performance is not to be mixed with substituted contract. If a contract is substituted for the original contract, it is already covered under section 62 of the Indian Contract Act. It is a novation. In place of old contract, if the new contract is substituted, it is called novation, and this is not what is spelled out in newly amended section 20 of the Specific Relief Act. There is a difference between specific substituted contract and a substituted performance. So what is the substituted performance? I'll give you an example. Now suppose if a contract to build a house is given by the owner to a contractor. The contractor builds house halfway. He constructs, say, only a shell and is unable, he commits a breach. For some reasons, he is not able to complete, or willfully or maybe by the circumstances. In such an eventuality, the aggrieved person need not go to the court of law and file a suit for specific performance, wait for the decision to come and then to complete the incomplete work. No. He can take shelter of newly added substituted performance and get the remainder part of that contract performed by his own agency or by a third party. Now, if he does that, the law protects it. This is what is a substituted performance. Now, naturally, you consider the same example. The house which is half constructed, left by the previous contractor, and the owner is required to get the performance substitutedly done through a new contractor. The new contractor is obviously not going to do it at the same old rates. So the difference between the new rates and the old rates, which the owner shall have to give to the new contractor, can be claimed as and by way of damages. This is a substituted performance. Substituted performance means not a new contract. It is only the completion of an incomplete part of the contract. You can well make some minor changes, while naturally when a new contractor comes in, steps in, you will have to, make some agreement kind of with him to complete the incomplete work. See, there is what is called as a concept of equivalence. That means that the material terms of the old contract or old agreement and the new agreement should be same. Then only it can be called as a substituted performance, not otherwise. Else it will become a substituted contract. That is not it. Minor changes can be done. Say for example, if previously there was no arbitration clause and in the new there is an arbitration clause incorporated, fine. But material terms should remain the same. Now if the material terms remain the same and if the owner gets the incomplete work completed through a new contractor, well, he can also claim damages. That is what is the protection given in the new concept introduced as a substituted performance. Now, in fact, this concept is not very, very new. In the government contracts, there is a clause called as cost and risk clause. What is cost and risk clause? It is the same. The government cannot afford the impediments in the infrastructural work once it begins. So now if the contractor halfway leaves or commits breaches, there was already a habit of incorporating the clauses, that is the cost and risk clause in the agreements, which the meaning of which was maybe that in case of the default by a contractor halfway, the government would be able to maybe get the incomplete work done through a new contractor and claim damages. But then that was a contractual right. Now it is made a statutory right. It is a statute now. Even if your contract is silent, even if your agreement is silent, you can seek a substituted performance. Substituted performance, you need not go to the court. It is without intervention of the court, mind you well. The only sine qua non, the only prerequisite to get the substituted performance done is that the law mandates, section 20 subsection 2 lays down that if there is a default done by a perpetrator, the contractor say, for example, the owner can give a notice to the contractor, that is a cure period. One month, 30 days notice is contemplated in section 20 subsection 2. 1 month's notice is mandatory if the aggrieved party, if the party which has suffered the breach by the other party has to get the substituted performance done, it has to give 30 days notice. That means if the erring party, if the wrongdoing party wants to set right the things, it can take the measures accordingly within this cure period of 30 days. Well, if that party does not do anything, even in that period of 30 days, then the person who has suffered the breach is at liberty to get the substituted performance done through his own agency and or maybe through a third party. He can claim damages, that is the difference, as I said some time back, difference in prices, whatever. He can claim as damages, but that claim can be made, claim for damages can be made only after obtaining the substituted performance. Now the requirement of giving a notice is that brings about what is called as a reasonableness. Every act has to be reasonable. Now this remedy is quicker. Substituted performance is a quicker remedy. Why? Because one is not required to go to the court of law. He has to give notice, 30 days, wait. If the erring party continues, defaults, then get it done through some other agency and claim damages. So quicker, without intervention of the courts. Then it also takes care of the loss that is suffered, because Section 20 subsection 3 says that after obtaining a substituted performance, the party which has suffered can claim even the damages. The performance is secured. Substituted performance means the performance is secured. So that is again something which is in accomplishment of the basic objective of taking away the discretion and making sure that the specific performance becomes a rule. So substituted performance is a very interesting aspect, a new concept. I feel that there is an ample scope for further evolution, because I minutely read this Section 20 on several occasions. Also consulted with my colleagues. I was a bit wary as to whether this substituted performance can be had only by the government agency and in the respect of infrastructural projects, or it can be had even in the individual contracts. Now consider the placement of this section. Section 20, the caption is the substituted performance, and then there are newly added sections 20A, 20B and 20C, which deal with the infrastructural projects. So maybe the intention of legislature can be to allow the substituted performance only in respect of infrastructural projects, because of that is one thought, because of the peculiar placement of section 20 and then annexing to it sections 20A, 20B and 20C. But again, if that is an interpretation, then it is not stated in section 20 by itself that the substituted performance must be had only in respect of infrastructural projects. So as the plain reading of the language goes, one can have the substituted performance even in the individual contracts. Well, now this is something which needs a further evolution. I'm sure now this act is introduced very recently in 2018, October. So maybe as the cases go to the higher judiciary, the high courts and the Supreme Courts will consider all the pros and cons and maybe give appropriate rulings to let us all know as to whether the substituted performance concept is available even in respect of the individual contracts, and if that is so, then in what manner should that substituted performance be had? Because individual contracts, the person, suppose if I give a contract to some builder to develop my property and he leaves halfway, and I am required to get the substituted performance done, I will maybe not able to do it as effectively as the government can do. The reason is that I am not that mighty. I do not have all those powers under the law to maybe do some forcible acts as well. So this all would require, according to me, a further evolution and let us wait and see how eventually the law as regards the substituted performance gets developed. Now, whenever there is any amendment introduced, whenever any new law comes into force, there is always a debate. And the debate is as to whether the amendment introduced is prospective or retrospective. Normally, in order to understand as to whether a particular amendment is prospective or retrospective, one is required to see is as to whether there is any saving clause or whether there is any clause referring to the transitory provisions. Well, now in our amended Specific Relief Act, there is no such saving clause or the transitory provisions clause. So it is difficult just to understand as to whether the act is prospective, the amended act is prospective or retrospective in nature. See, normally there are certain norms to decide as to whether a particular act is prospective or is retrospective. Whenever any amendment or any new act is declaratory or clarificatory, it is regarded as retrospective. If the amendment is simply remedial, it is not regarded as retrospective and it is required to be held that it is a prospective act. There could therefore be no room to come to any conclusion that this has a retrospective operation. In my opinion, this amendment introduced in the Specific Relief Act in the year 2018 is prospective in nature. There is one other angle. We all know that there is what is called as the General Clauses Act. Section 6 of the General Clauses Act lays down that if any act is repealed, the repealed act or the introduction of a new act will not affect the rights and liabilities which have already become available to a party prior to the introduction of that amendment or introduction of that new act. Now consider the Specific Relief Act prior to the year 2018 was what? The courts had discretionary powers. If I bring a suit for specific performance of the contract, I was required to prove that there exists no standard to ascertain the quantum of damages. I was required to prove that compensation in money is not going to afford an adequate relief to me. I was also required as a plaintiff under the old act to prove the other parameters to eventually make the honorable court to decide the matter in favor of granting an injunction. Now this was my obligation. So consider that if I have filed a suit in 2017, that is prior to the amendment, and today in 2020 or maybe in 2021, this suit is going to be heard and decided by the courts. Which part of the act will apply? Whether it will be old act or it will be new act. This will be governed the suit which is filed in 2017, that is prior to amendment, and which is going to be decided after introduction of the amendment, will be decided on the basis of the specific relief act without the amended provisions. The reason is, the rationale behind this is that as per the General Clauses Act, I as a plaintiff in a suit for specific performance was under an obligation to prove the requirements of section 10, which we just now saw, and the other parameters to enable the court to use discretion in my favor. These were my obligations when I filed a suit. Now, my obligations are, they bestow a corresponding right upon the defendant. What is that right? That right is that my suit cannot be decreed unless I have proved all the parameters, I have surpassed all these parameters. So what I'm trying to emphasize before you all is that the amendment has no retrospective operation in respect of the suits for specific performance, which we have filed prior to amendment, will continue to be governed by the old act without an amendment. But in respect of new suits which are filed after an amendment, they will be governed by the new act, no matter that the contract was entered into prior to amendment. While considering as to whether a new act applies, that is the amended act applies, or the previous act applies, what is important is the date on which the cause of action has arisen. If the cause of action has arisen after amendment, even though the agreement was made prior to amendment, the suit will be governed by the new act, otherwise by the old act. Well, this is all about the Specific Relief Act, overview of the Specific Relief Act and the amendments introduced in this. I'm aware that you all know that the word specific performance, injunction are the keywords in today's practice. You all are very, very much aware, well versed with these words, and all of you are really doing a fine practice, I'm sure. I accepted this invite from the office bearers of the TDCBA, not because I thought you have no knowledge about it, but because I wanted to refresh my knowledge about the Specific Relief Act and about the latest amendment introduced in the Specific Relief Act. I take this opportunity to thank the committee and all the office bearers for having given me an opportunity to express my few words and refresh my knowledge about the act. And I also thank to all of you for having heard what I said patiently for all this time. Expressing thanks and gratitude to the committee and all of you, I conclude my discussion. If anyone has any doubts, I'm not aware, but you can ask me questions. I will try to give an answer, provided of course I am able to know from the screen what the questions are. Thank you very much again. I'll wait for 2 minutes and then I will close. Thank you. Thank you very much. All right, thank you very much. You are always welcome. You all have my number. You can anytime contact me. We can exchange thoughts. We can discuss on many things. Thank you. Thank you very much. Thank you.